types of relationship between the property owner in these situations. Briefly, the inspection results. The Housing Authority inspected about 6,400 living units in 2015. Again, these could be either a single family home or most likely a single apartment within a building. 2/3 of the units passed their initial inspection, and that's important so that the tenant is able to move in quickly and without delay. Now, they can certainly move in if there's a failed item that is not a life safety situation, but contract payments to the property owner will not start until that unit passes the inspection. The two top violations, again, concern elements inside the unit, whether it's loose material from the ceiling, walls, floors, some sort of air infiltration, or windows that are broken, inoperable, missing screens. And then nearly all the failed units pass their reinspection on the first time. So again, it's important for the tenant to be able to get in there quickly as possible as soon as the unit passes inspection so that the payment contract begin. Again, the city of Minneapolis, they inspected 4,700 properties, again, focusing mostly on the buildings themselves, the structure, the common areas. Nearly all the properties have at least one violation. So when you're looking at 244 different ordinances or codes, you're likely to find something wrong. And with 1 to 3 unit apartments or one single family to up to triplexes, you've got a large number of the violations being concentrated in 20% of the properties. So it's a very different situation from what the Housing Authority is looking at. Some of the top violations that the city finds are that no licensed contractor has inspected the furnace. That is not intended to mean that the furnace is improperly functioning or is a danger, but that there's been no inspection of it by a licensed contractor to make sure it's properly functioning. Some of the other types of common violations are illegal occupancies and exterior damages, problems with the roof, exterior walls, basement or foundation structure. And of course, for larger buildings, 4 or more units, because the focus of those are on the fire code, the top violations concern something with either exit signs or doors being propped open or units not being properly numbered. So given some of the differences I talked about, some of the inspection results, I want to emphasize why there are some challenges to coordination between the Housing Authority and the city one. First of all, different inspection standards. If you wanted to have both the Housing Authority and the city have the same standards, you would probably have to raise the Housing Authority inspections up to the city level, and that might decrease the availability of rental properties for voucher recipients. It might also discourage owners from participating in the voluntary voucher program, especially if they. The Housing Authority inspections are part of a larger process that begins with eligibility determination of the recipient. The recipient finds a potential property to rent. The Housing Authority checks for rent reasonableness, and then the inspection happens. So there's a 3 or 4 step process. None of that process is part of the city process. The city just goes out and inspects the unit. Finally, most of the voucher units are in multifamily buildings, and if the city were to take over the Housing Authority inspections, you would have fire inspectors who are trained on the fire code, spending their time looking at individual units when their role is really to look at the safety of the entire building and a small portion of the units. And then finally, if the city were to take over the Housing Authority inspections, it would likely be a separate unit within the larger Department of Regulatory Services. And that's no advantage over to what is the current situation. Regulatory Service has inspectors all over the city. They can respond quickly to a request, but if it's a special unit, then you're going to have the same situation that you have now with separate entities. So with those coordination challenges, I'm recommending sort of a gradual growing together of the relationship. One, by first of all sharing information electronically, giving each other access to their inspection systems, And two, having the city conduct the housing authority's complaint inspections, which are a very small part of the housing authority's work. It's a very large part of the city's work, and there may be multiple complaints at a single property that is either reported to the city or to the housing authority. I don't want to spend too much time on my specific recommendations for the housing authority because they were already discussed previously by the previous speaker, but a couple of recommendations to address peak times, like at the end of the month when there are more units available, that they add a second inspector to help with those times. Go to more biennial inspections for most of the buildings, and a couple of recommendations how they can shorten the time between when the rental unit is available and when the inspection occurs and the contract happens, because that can delay payments. For the city, recommending create a shorter inspection checklist, focusing on the most common deficiencies, reducing the required number of units to be sampled. Right now it's at least 20%, but after they looked at 30 units within a building, they can probably guess the 31st unit is going to be similar to the other ones. And then finally, given that a small number of property owners cause a significant amount of the violations, to impose higher reinspection fees for those situations. And I can take questions, or I know there's maybe comments from the authority or Department of Regulatory Service on the recommendations.
Thank you, Mr. Butler. Are there any questions of Mr. Butler? Right, seeing none, thank you. And Mr. Russ and Mr. Director Schuckman, if you both want to just comment on this, and we can move on after that.
First of all, this was an excellent report. We've been in discussions with city staff now for a couple of months, going through the recommendations. A couple of observations from the Housing Authority side. We do agree that we think we could share data in a way that from our side might make it easier for us to reward landlords who have a good track record in terms of how we go about our inspection. Federal law now permits us to look at using third-party inspections where previously it didn't, so we could piggyback on work that the city has done or is doing in a different way, so we're definitely going to look at that. I think we're also going to look at where there's non-life-threatening issues under HQS, trying to adjust our payment process so that landlords are not penalized in any way by timing on our side. The third thing we'd like to do is work with the city to see if there's some potential in the small area that the consultant described on the complaint inspections. So the data sharing, I think, would be tremendously helpful. We're thinking that why not reward those who are taking care of their properties, and we could think about really changing the inspection protocol on our side if we have a recent city inspection, say, or something that we can build on. So those are things we're really interested in from our side.
Thank you. I share Mr. Russ's positivity about the study. This is, as I mentioned earlier, this is something we've been hoping to have a conversation about for some time. I want to thank MPHA staff for participating. We also are looking forward to data sharing and exploring the opportunities to look at the complaint-based inspections. Of the three specific recommendations for regulatory services, the only one that I have some concerns about is reducing the number of units that we get into in larger buildings. I think, frankly, we need to look at going in the other direction. But otherwise, they're all very actionable items, and we look forward to working on them.
All right, thank you. Are there any questions? All right, seeing none, I will move for us to receive and file items number 1 and 2. And I don't believe I need a second on that. So is there any discussion on those 2 items? All right, seeing none, all those in favor, please say aye. Aye. Any opposed? All right, motion carries. Now we will have a presentation by Andrea Brennan and Noah Schuckman with regards to item number 3.
Good morning, Chair Yang, Chair Goodman, and members of the committees. City staff have reviewed national best practices to encourage landlord participation in the Section 8 Housing Choice Voucher Program. We learned that funds called guarantee or incentive funds are used by several jurisdictions, including Portland, Oregon, New York City, Fargo-Moorhead, and Metro Council HRA. Additionally, the U.S. Department of Housing and Urban Development, or HUD, previously funded damage claims and rent loss claims, both of which were incentives for landlord participation in the program. As a potential complement to the ordinance proposal before you today, city staff have worked very closely in collaboration with Minneapolis Public Housing Authority staff to develop a concept for a landlord incentive fund. The fund is designed to further eliminate barriers to acceptance of Section 8 housing choice vouchers. Potential uses of this incentive fund include damages caused by housing choice voucher tenants that are not covered by the tenant security deposit, lost rent due to partial month vacancy, and one-time incentive fee for first-time property owner participation.
Thank you. As we've worked through this proposed structure with MPHA staff, there's a proposal to do 2-year, $25,000 per year funding for the damage portion of the fund. In the best practices research on this, there's actually a very small number of claims to these funds around the country. And so we are fairly confident this is an appropriate amount. We would use problem properties unit staff to do an assessment of damage inside of a property, and then have them do a reinspection to make sure that it was completed, any repairs were completed to code. MPHA, and in our discussions with MPHA, they have been willing to administer the fund and to provide a financial contribution as well associated with the incentive portion for landlords taking Section 8 tenants for the first time. And so it's an ongoing part of the conversation for both organizations. The staff direction in front of you would direct city staff to work with MPHA to continue to develop the program, establish a memorandum of understanding, and report back to committee by September 1st. We're happy to stand for questions.
Okay, we are going to just keep on moving along, and so we will hold on the action items for item number 3, and we'll move on to item number 4, which is presentation by Andrea Brennan.
Thank you again. So this item is partially a house cleaning item as well as partially strengthening city requirements around affirmatively furthering fair housing. Longstanding City of Minneapolis policy prohibits Section 8 housing choice voucher discrimination in residential projects that have received some form of financial assistance from the city. This requirement is enforced through a contract between the property owner and the city, and that contract states that the owner may not refuse to lease a unit in the project because the prospective tenant is a Section 8 voucher holder or a participant in a home tenant-based rental assistance program. In an effort to make sure that this requirement is known more broadly, staff proposes to amend the city unified housing policy to just expressly state that we have this policy. Additionally, staff proposes that we amend the policy to also add new requirements around affirmatively furthering fair housing choice. So that would add a requirement for owners of city-assisted property to be basically to do more to make sure that that the availability of these new housing units is known throughout geographies in the city. Finally, we have done some review of our monitoring of this requirement to not discriminate against Section 8 voucher holders. And we have identified some gaps in that monitoring. So we would also propose that we develop processes and procedures to make sure that we are monitoring for enforcement with both of those provisions.
Thank you. And we are going to hold questions and move on to item number 5, which is the public hearing. And again, I just want to mention that if you wish to speak, if you can sign up with the clerk, that would be wonderful. We're allowing 2 minutes for speakers. And, with that, we will start with item number 5 by having a presentation by Ms. Volchak. And hopefully it's a short presentation and then we can begin with the public hearing.
Thank you, Chair Goodman, Chair Yang. So you've heard some data, but I just want to remind you, if we're looking at the census from 2010, we see that of the Twin Cities population, 24% of them identify as people of color, and it's projected in 2040 that 40% of the population will identify as people of color. But when we look at HCV, the demographics of HCV holders, what we see is that they represent a disproportionate amount of people of color. As was already indicated by Mr. Russ earlier, if we look at this snapshot, approximately 76% of HCV voucher holders identify as Black. If we look at gender, we see that 77% of HCV voucher holders or Section 8 recipients identify as female, or 77%, excuse me, I think I said that, identify as female head of household. Approximately 39% identify as having a disability. And of the 17,000 residents served by MPHA, approximately 52%, I believe Mr. Russ said 53%, are children. So how can the city support opportunity for HCV voucher holders? And the answer is passing this ordinance amendment and putting HCV voucher holders on equal footing with people who do not receive rent subsidies. This, and I want to make this very clear, this ordinance is not a mandate. It is a request to put housing choice voucher recipients on equal footing for those who do not have subsidized rent. It is very analogous to employment law. In employment law, when an employer advertises that they have an open position, they cannot put in their advertisement African Americans, Asians, LGBTQ, Hispanics cannot apply to this position. There is an individualized assessment based on objective criteria of whether all applicants can in fact, or whether all applicants fit the criteria and would be the best person for that position. That's exactly what we're asking for here in this ordinance, that there's an individualized assessment to see if a housing choice of voucher applicant meets the criteria of the tenant that you want in your unit. Homeline did a study recently, and of their sample, they came to the conclusion that 2/3 to 3/4 of all available units were off limits to HCV voucher holders. Now, if you look at that chart and you look at the no's, some of those no's comprise units that are above the rental standards set by Minneapolis Public Housing Authority. But also some of those no's are within the rental limits that are set by the Minnesota Public Housing Authority. So HCV voucher holders could apply there. So like I said, if you pass this ordinance amendment, you could support housing opportunity like the 9 other states and the 49 other municipalities around the country who have housing choice voucher protection. Here are the 9 states, the earliest of which was enacted in 1975. And then here are the 49 local legislative protections, the earliest of which was 1975 also, but we also see them in comparable cities such as Boston, Chicago, and Seattle, and Philadelphia. So let's talk about who's covered under this ordinance, who would be subject to this ordinance. And it would be all owners, landlords, managing agents with 1 or more residential dwelling units for rental, lease, or sale. There are some exceptions. owner-occupied units, single family, or dual or double units. And then those who had homesteaded their property and rented it for only 36 months, which is approximately 3 years, their condo, townhouse, or housing cooperative. And that includes with active military servicemen also. So who are the covered agents and organizations who would be subject to this ordinance? All persons and organizations who sell, rent, and lease real estate. Covered tenants, housing choice voucher tenants, Section 8, and then others who receive federal or state local assistance. That's including but not limited to medical assistance, rental assistance, and rent supplements. This is where it's not a mandate comes in. If a landlord says, I can't rent to the Section 8 recipient because there's going to be significant difficulty or expense in renting them to that person, then they can tell the office that they can enact this undue hardship, and then they would not have to rent to the housing choice voucher recipient. And we sought to codify some of those, some of the things that we'll look at: the nature and net costs of complying, the financial resources of the landlord, and the impact on the business. What also does not make this mandatory is the fact that, as Mr. Russ said, that landlords still have the ability to screen. That's not taken away from them in this ordinance. They can restrict the occupancy to the amount of people that the occupancy is supposed to have. They can look at rental and lease history. They can apply any other screening criteria that's enumerated in local and state laws. From the civil rights perspective, we would ask that the ordinance would be effective and enforceable on May 1st, 2018. That is approximately a year out. It would give us an opportunity to identify staff to engage in informal inquiry, which I'll talk about in a second, create and translate notices, FAQs, and perform targeted outreach with the assistance of the Neighborhood Community Relations Department within the city, so we can make sure that everybody has knowledge and education about their rights and responsibilities under the ordinance. So prior to that May 1st, 2018 date, if we hear of someone saying, I believe that I was discriminated against because I'm an HCV recipient, then we would provide educational notice on the ordinance amendments and when it would be enforced. If we have violations after the May 1st, 2018 date, when it's enforceable, then the violations would go through our normal administrative process that has been put in place and that we've exercised for decades within the Minneapolis Civil Rights Department. And I won't get into the intricacies of it, but generally what happens is that someone will call us and they will have a complaint, and we ask them, do you want to come in to file a formal complaint against somebody? But in this case, and this is basically due to the fact that we called different states and asked them about the urgency of placing a voucher. I mean, time is of the essence when in the placement of the voucher. So did they have a mechanism in which to kind of triage so they didn't have to go through a full formal complaint process? And the answer that we got was, well, yes, there is. What they did and what we'll adopt formally is that when someone calls in about a complaint, we will call the landlord just like they do and see if they're the reason for the issue and whether they're educated about the ordinance and the requirements of the ordinance. And, you know, the jurisdictions that we talked to that did this said that actually 95% of the time it worked and that people were placed in the unit. So that's something that we'll, like I said, put into a formal process. But if there is not an agreement and the tenant can come in, file a complaint, We've put them through early mediation, hoping to settle. We have a robust mediation program. And then if that doesn't work, then the landlord, just like any other respondent in our office, can formally file a response as to why they did not take the tenant. And then our office does an objective investigation like it normally does. And then we render a legal determination on whether there was probable cause for discrimination or no probable cause for discrimination. If there's probable cause for discrimination, this is the relief that people could see. There are a well-established appeals process for the tenant, which is listed here. And I know that we're running out of time, so I won't go through it specifically, but tenants can appeal to the Minneapolis Civil Rights Commission. If it's upheld, they do have the right to appeal to the Minnesota Court of Appeals. A landlord has an appeals right to a certain extent also. When there's a finding of probable cause for discrimination, we encourage people to go through the conciliation process, which is a settlement process, but respondents don't have to do that. And sometimes people will go through the conciliation process and there just won't be an agreement. So if that's the case, if they decline to go through conciliation or there's no agreement, then you can get a full hearing in front of the Minneapolis Commission of Civil Rights, in front of the attorney members. So in conclusion, I'd like to just reiterate, this is not a mandatory ordinance. What we are attempting to do is to put HCV voucher holders on equal footing with those who do not receive rent subsidies. We are looking for an objective analysis on whether, in fact, an HCV voucher holder would be the best tenant for a particular unit, just like there's an objective analysis for those who don't receive rent supplements. So that concludes my presentation, and I'm able to stand for questions.
Thank you so much. I see that Councilmember Gordon's on the queue. So, Councilmember Gordon.
Thank you very much, Mr. Chair. I have a question about the undue hardship piece.
Mm-hmm.
It looks like in the ordinance, the undue hardship, it just relates to public involvement in a public assistance program. So you can't claim an undue hardship if you discriminate against somebody who's gay or black or of a different religion.
That's correct. We do have undue hardship in employment for accommodation based on disability, but that's the only other time that there's an undue hardship. And then this ordinance amendment would provide that space also.
It feels like that could be a fairly large loophole to me when I'm just reading the language and I'm concerned about it. Could you give me an example of what might just be a common undue hardship that somebody could use to get around this?
Sure, I'll use the simplest example. If someone has a rental unit and for some reason that there's a lag in inspection and you can't get the tenant in, and so you might have, it looks as if that a unit might be open for a month or something. But you the way that your business is constructed, that you can't do a cash float. You can't have that unit open for a month because the money from that unit might help to go pay for the actual rental property, the mortgage on it. So that would be an example in its simplest terms of an undue hardship.
Okay, thank you. That also sounds like it might be a motivation for the inspections program we were talking about earlier to get it better organized.
Correct.
All right, thank you.
Thank you for the presentation.
Thank you.
I will remind folks again that if you want to speak, if you can sign up with the clerk right there at the corner, that would be wonderful. I'm going to ask staff, city staff, if you can just make note of issues and questions that are recurring, just so that at the end of the public hearing, we may call you up to answer some of those questions. And, for the speakers, if you come up, please state your name and your address for the record. I will, if you don't give your address or your name, I will continue to bother you and eat up at your time, okay? So just want to do that. I want to point out that Councilmember Palmisano is going to be my enforcer of sorts. So if you hit your 2-minute mark, she's going to slowly move you along. So with that being said, we will start the public hearing, and I will open the public hearing at this point. And our first speaker is Jamie Long from the office of Congressman Keith Ellison. Please, Mr. Long, come up here.
Thank you. Good morning. My name is Jamie Long. I'm the district director for Congressman Keith Ellison. Chairman Yang, Chairman Goodman, thanks for inviting me to speak today. Congressman Ellison sits on the House Financial Services Committee, which has jurisdiction over the Housing and Urban Development Department, as well as over Section 8 vouchers. And so he has a distinct interest in this issue. We have an affordable housing crisis in the Twin Cities, as you know. We are losing affordable rental units faster than we can build them. And we have a 2% vacancy rate and are seeing rents rapidly rising throughout Minneapolis. In theory, one of the key features of the Housing Choice Voucher Program is that it offers its users choice and the ability to find a place to live in their preferred neighborhood. In reality, we know that voucher holders have very limited options, as many landlords and property management companies refuse to rent to Section 8 tenants simply because they are